Hello, and welcome. This is Crime in Court, and my name is Heather. And I'm here with a new Idaho 4 update. There were, between the Thursday and Friday of this week, there were multiple filings within the Idaho 4 case, so we're going to dive into them. They're very short, so instead of doing a short video for each separate one, I'm just throwing them all in here. So the last motion that we read was the defense, Brian Koberger, was trying to move for a new change of venue. So this is actually the state's response to that. They are objecting to the defendant's request for scheduling and changing the venue. They really want it in this town, apparently, and I don't know, but it seems like they must want it in the town and in the summer. But if they could move it out of the venue, then they don't need to be tied to the summer trial. So I think moving it is only a benefit, but let's see what their objection is at this point. Comes now the state of Idaho by and through the Latah County prosecuting attorney and objects the defendant's motion to change venue as it is premature. The state requests that this court set a trial date, a briefing schedule for defendant's motion, a hearing date for the motion to be heard, and a deadline for supporting memorandum, affidavits, and witness disclosures sufficiently in advance of hearing so the parties can adequately prepare. Defendant's motion to change venue is premature and without sufficient basis. Defendant has not provided the court with adequate information to conclude that the Latah County jury could not fairly and impartially decide defendant's case. In Idaho, a motion for change of venue is within the direction of the trial court, State versus Wynn. Idaho's appellate courts look to several factors while determining whether a trial court exercised its discretion in deciding the motion to change venue, including, quote, affidavits indicating prejudice or an absence of prejudice in the community, end quote, and, quote, testimony of the jurors at voir dire as to whether they had formed an opinion of the defendant's guilt or innocence based upon adverse pretrial publicity, end quote, and that is coming from States versus Needs. So they're saying that they need to have affidavits from people within the jury pool or somebody, stating that there is a prejudice within the community. There needs to be some kind of basis for that statement, and then some kind of evidence for that. And then also, the state is saying we have to go through the whole jury selection process in order to find out if the jury's, because voir dire is when they select or eliminate jurors, until they get it to the jury that they want. So this is basically saying that without questioning the jury pool, you don't know that they have some kind of bias yet or not. Other factors for consideration are whether a defendant challenged for cause any individual jurors, the nature of pretrial publicity about the case, and the duration of time between the publicity and the trial itself. The Idaho Supreme Court has also explained that publicity by itself does not require a change of venue. Because publicity is not a standalone reason for a court to change venue, this court should decline to decide defendant's motion until a trial date is set and the court has heard adequate facts to enable the court to make a determination. The state respectfully requests that this court set a trial date, set a hearing for defendant's motion to change venue, issue deadlines for supporting memorandum and affidavits, and set deadline for witness disclosures reasonably in advance of hearing. And that was signed by William Thompson Jr. of Latah County Prosecuting Attorney, and Ingrid Beatty, Special Assistant Deputy Attorney General. So then that was e-filed on the 8th of February. So this past week. Now, this next document, so that's that. They're objecting to the change of venue at this point. He wants a hearing first. Now we are on, still on the 8th, Ann Taylor submitted this, it's a motion requesting clarification of the sealed order for disclosure of IGG information and protection order. So comes now Brian C. Koberger by and through his attorneys and hereby moves this court for an order clarifying language contained in the sealed order for disclosure of IGG information and protection order filed with the court on December 29th, 2023. So they finally got some kind of disclosure on the IGG, but now Anne wants to know what's sealed. She wants more clarifying language regarding the seal on this. So the court's sealed order states that, quote, no individual on the family tree may be contacted by the defense or any agent of the defense without prior authorization from the court after a showing as to why such contact is necessary and material to the preparation of the defense, end quote. So the defense, as part of the necessary work, has previously identified family members and work is being conducted. The defense does not expect to use the protected materials to identify people to contact without further order of the court. However, the defense needs to continue its investigation with witnesses and resources generated from sources outside of the protected materials without worry the plain language of the protected order could be implemented to prevent that work. The defense seeks clarification of the specific language of the protective order. So it looks like they probably have some information on family members that they're trying to obtain, but they don't want to disobey the court's orders. So they just want to make sure that they're doing it on the up and up. No individual of the family on the family tree may be contacted by the defense without prior authorization. So they're just trying to make sure that they're staying within this particular order from the court. Now comes the next filing, which is also from the state. So we're back to the state's response. This is to the defendant's motion to allow certain experts and investigators protected access to view IGG materials and a motion requesting clarification of the sealed order for disclosure of IGG information and protection order. So these came out, I think the end of December, early January, where they were allowed to finally, the court made the decision that some of the IGG information was discoverable to the defense. So they were ordered to turn that over, and that there were, as always, some kind of parameters on it with the court. So here is what the state's response to the latest in that is. So comes now the state of Idaho by and through the Latah County Prosecuting Attorney and respectfully submits the following responses to the defendant's motion to allow certain experts and investigators protected access to view the IGG materials filed on February 1st, 2024, and the defendant's motion requesting clarification of the sealed order for disclosure of IGG information filed on the 8th. So now they're still, the IGG was turned over, but now they're still working on like what the defense can do with that IGG information, who has the right to see that. They're trying to get certain experts, because there's a gag order, because it's sealed. They're trying to allow the experts that they need the access and permission from the court to to do so. So regarding the expansion of the protection order to include Dr. Lee Larkin, Becca Barlow, and Steve Mercer, the state does not object. So the state is allowing them to share the IgG information with these individuals that they just listed. Regarding the expansion of the protection order to include unnamed, quote, criminal investigators, unfettered access to the IgG materials, the state objects. At a minimum, individuals who will have access to any of the IgG materials should be named. So the state wants to know everyone that looks at the IgG information, which I don't think the defense should have to do, because the state doesn't have to tell them who looked at it when, we've got discovery issues and line of custody issues, I think, regarding this regarding this data, the IgG data. So further, defense has failed to make an adequate showing as to why such individuals need the information for the preparation of the defense. Defendant states that the information is requested to, quote, investigate how and when Mr. Kohberger was identified as a suspect, end quote. And that is exactly why we need the IgG. How did they even get onto Brian Kohberger? Because we, to this day, have not been told a legitimate reason as to why it's him. So this information can be obtained from the TUI letter from the FBI to the state dated November 28th, 2023. The state objects to the balance of the IgG materials being provided to the criminal investigators for the reasons articulated by the court. All right, I'm trying to scroll my page and it's not going anywhere. Regarding the defense's motion... We're having some lag issues here. Sorry, guys. Scroll back up. Regarding the defense's motion requesting clarification of the sealed order for disclosure of IgG information and protection order, the defense experts or investigators should not be allowed to use the protected materials to identify individuals or witness to contact without prior authorization from the court and after showing why such contact is necessary for the preparation of the defense. This would not prohibit the defense from contacting potential witnesses learned throughout sources outside of the protected information. The state respectfully submits that the appropriate course of action would be for the court to amend sealed order for disclosure of IgG information and protection order to allow Dr. Leah Larkin, Becca Barlow, and Stephen Mercer access to the IgG materials disclosed to the defense. So that's a win for the defense that they are allowed to share this information with these experts. The criminal investigators seeking access to the information, though, should be named in the order, and those investigators should only be allowed access to the November 28, 2023 letter provided to the defense. The state also requests the following language for an amended protective order. The court orders, so this is their, this is the requested language that they're using. So this isn't an actual court order, but this is what they're saying. They are asking the court to put language to their previous protective order that's in place. All right, so the court orders that only defense counsel Ann Taylor, Jay Logston, and Alyssa Masseth, defendant Brian Kohberger, and Dr. Leah Larkin, Becca Barlow, and Stephen Mercer may view the materials provided. Insert the names of the criminal investigators. May view the November 28th, 2023 letter contained within the materials. Any further dissemination of the materials or the information contained within the materials must first be approved by the court after an adequate showing by the defense as to why such information is necessary and material to the preparation of the defense. Additionally, no individual learned solely through the review of the materials. Sorry, I just lost my place. Or the information contained within the materials must first be approved by the court after an adequate showing by the defense as to why such information is necessary and material to the preparation of the defense. Additionally, no individual learned solely through the review of the materials shall be contacted by the defense or any agent of the defense without prior authorization from the court after an adequate showing as to why such contact is necessary and material to the preparation of the defense. So they are really trying to limit, as long as, well, I don't know if necessarily they care about the fact that it's limited. Maybe they just want to know who it is, because they didn't object to any of the other experts. But they're objecting to anyone else that they don't know at this time. So maybe, if Anne comes back and says we have these specific individuals, then they'll allow it. It seems like they should. So that was from the AG's office, and it was filed the 9th of December, certified. So that's it for those 3 filings for the latest of the Idaho 4. Let's see. It'll be interesting. It'll be interesting to see if Anne comes back with more on the motion to change venue with, affidavits or something saying, or case law saying like, hey, it's not too early and we have enough reasoning to change it. I don't know. What do you guys think? Do you think they'll change the venue? Do you think that'll get denied? Do you think that they're onto something with this IGG information and trying to go backwards and figure out how they got to Brian? Because it's really interesting to me. Anne said in one of the latest hearings, she said flat out, she's like, I don't know how we got to Brian. And she's looked through the case material, the files, everything over and over again. She doesn't know how they've picked Brian out of everybody, out of the suspects. So let me know your thoughts on this case. It's interesting to me. I'm not like a Brian did it or didn't do it. I don't know. And I'm just here for seeing the court process and trying to read all the documents and see how it goes. So let me know your thoughts down below, and thank you so much for joining me. I hope to see you next time. Thanks so much. Please like, share, comment, subscribe. Bye. Take care.